Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer.
Hi, Rebecca.
Hi, Sarah. How are you?
I am great because I'm excited to talk about. We had a bit of a teaser at the end of our last episode.
Yeah.
And I've just been really excited to be able to follow up on that. I'm sure our listeners really have been on the edge of their seats. What is it? What is it that Sarah thinks we should be thinking about?
To be clear, we're talking about employment lawyer excited.
Yes,
so
exactly.
Curb your enthusiasm, everyone.
Exactly.
This is employment lawyers getting excited. And I am happy for you as your friend and partner so you have an opportunity to get this off of your mind. And not just to me, right?
Yes.
Because I know this really, truly has been something that's been on your mind.
I've been thinking about this, right?
Yeah.
I worry about employers. I think about these things. So
without further ado, Sarah, what are you talking about?
Here's what it is. Okay. So I know, as do all of our listeners, that employers are facing incredible challenges right now in finding people to hire, right, to come and work for them in so many areas across so many industries. And we also know that they're starting to think really creatively about how to draw those people in. We're hearing about hiring bonuses and stay bonuses and fun benefits, right? Unique benefits that an organization might offer. And one thing we're also hearing so much about is increased starting wages.
Yes. Do
Right?
you remember back in the before times?
Yes.
When there were protests and picketing to get organizations like McDonald's to pay
$15 an hour. Yes, right.
And now that's
Now it sounds like a
essentially the
joke.
new minimum wage, right?
Yes. It's going up and up and up and up.
Yes.
And employers are advertising starting wages are so much higher. It's all over the news, et cetera. Okay?
Yep.
And although, of course, I'm happy for the people who are getting higher starting wages, right? It leaves me unsettled. Why, Rebecca? I know you know why.
Well, right, because you've been talking to
I've
me
been
about
talking
it for
about this,
quite
right?
a long
Yes.
time. And
Yes.
that is because of something we call the EPA. But are we environmental lawyers,
No.
Sarah?
No.
Okay, so we cannot be talking about the
No.
Environmental Protection Act. So when you and I talk about the EPA, what are we talking about?
We're talking about something called the Equal Pay Act.
Yeah,
Rebecca.
something many HR folks have never heard of.
That's
They're familiar with the concept, to be fair.
Yeah.
Most of us are familiar with the concept, which generally is you can't pay one person more than the other because of their gender, right? Is that about summing it
Yeah,
up?
right, exactly. You can't, in particular, yes, you can't have a pay disparity between a man and a woman, right, for the same work.
And I'm sure everyone listening is thinking, okay, guys, I may not have heard of the EPA, but I knew I couldn't do that, right? There's a general sense that obviously that would be unlawful, right?
Correct.
And that's because there's also other laws, right, that could apply to something like that. Title
Sure.
VII, state laws that prevent discrimination.
Discrimination laws, right.
So what makes the EPA different?
Okay. Well, what makes it different is, first of all, it's specific to gender only,
Okay.
right? So it focuses on the pay disparity between men and women.
Okay.
And by the way, when it was first passed, believe it or not, in 1963, okay,
Long time ago.
the pay gap, 59 cents an hour for every dollar a man made an hour back when it was passed. We've closed that gap significantly. Now it's 82 cents. Okay,
Right. Still got a ways to go.
Still got a ways to go.
Yes.
But in any case,
So
the EPA is specific to gender, and it also has it falls under the Fair Labor Standards Act, which is your songbook, of course.
it's actually part of it, yeah.
And so it has some significant penalties attached to it. Double damages.
Yeah.
You can go way back in terms of timing of pay disparities, et cetera.
Attorney's fees. And actually the timing is interesting to me because that was passed before Title VII.
Yeah. Right.
So if people are wondering why would they have passed the Equal Pay Act if we already have Title VII? Well, the Equal Pay Act came first.
Sure.
Right, and it was only gender, and then Title VII obviously includes many more characteristics.
So going back to where we started, right? So that's the Equal Pay Act. Our listeners are probably still thinking, well, I don't get it. Why should I be worried about increasing starting wages based on the Equal Pay Act? And here's the answer. You and I now have defended EPA cases in federal court, right?
Yep.
The first thing I'll say is I have rarely seen ever an EPA case in which the employer meant to or intended to pay a female employee less than a male employee for the same work.
Well, I'll put a caveat on that. I have seen that.
Okay.
But I have not seen it where the reason is
gender.
Because
yes, I'm sorry, because
gender.
of their gender.
But there are plenty of times when an
Right.
employer intentionally pays one person more than the other
Sure.
for the exact same job. And when does that sort of thing typically happen? When there's a new hire,
Yes.
right? And the new person coming in
Right. Yes.
ends up being paid more.
Yes. And in every EPA case that I've defended, there is one common fact pattern, okay? And that is exactly that.
Yeah.
The events that gave rise to that lawsuit were that a new hire was brought in at a starting rate that was higher than one or more people already doing that same work for the organization, okay? And as it happened, unluckily for that employer, the new employee was male and one or more of the current employees were female, okay?
Yep.
Now again, it's not as if in the cases I was involved in, that business certainly didn't think to themselves, we're hiring a man, so I'm gonna pay them more than our current employees, some of whom are women. That's not how it worked out.
No.
They happened to pay a starting rate because they thought they had
Yeah.
to get that employee in the door, and they just weren't paying attention
Agree.
to the wages of their current employees,
Yes.
and it created this disparity, which created a lawsuit under the Equal Pay Act. And we have found under those facts, it's really hard to get a federal judge to dismiss an Equal Pay Act lawsuit with those facts in place. It's very difficult for an employer to articulate a good reason to explain that disparity.
So now that we've gotten everyone's attention,
Right.
What are employers to do? What do they do with this information?
Yes, what are the takeaways, right?
Yes, how can they help prevent this from occurring? And again, to be clear, we're not familiar with any organization intentionally, right, saying we're going to pay our men more than our women. Gone are the days.
Right.
That used to be a real thing. There used to be advertisements, want ads. Well, back when there were want ads, that used to actually advertise different wage rates for men and women.
Yeah.
So what we're
Probably
talking
why the gap was 59 cents for every gallon. Right.
what we're talking about is how that can unintentionally happen at your organizations and
Sure.
how to prevent that.
How
from
to not
happening.
stumble into an EPA lawsuit, right? Okay.
Right.
So first of all is to take head on exactly what I'm describing, right? For all of those organizations that are increasing their starting wages significantly, right? I can't recommend highly enough that if you're going to do that, that has got to come hand in hand with also looking at the wage rates of your current employees doing that same work.
Yes,
Okay?
exactly.
And
Yep.
that's not just because we're afraid of an EPA lawsuit, to be honest, right? But from a more practical standpoint, if you're bringing people in at a wage rate that is slightly higher or more significantly higher than what your current employees are making, you may be taking one step forward with a new hire, but you may also be taking 5 steps backwards because you're not going to keep your current employees.
That's correct. I mean,
Right.
presumably, if the organization is making a rational decision to increase the starting rate, they've done some sort of market analysis,
Yeah.
right? And they've decided that the new going rate, right, for that position is whatever it is higher
Is X.
than it used to be. But it could be that organizations are so focused on recruiting right now, which understandably really is the focus of a lot of HR departments right now.
Yes.
They're so focused on that, right? They raise the wage for new folks coming in their advertisements, and then, again, just inadvertently, right, forget to look backwards too.
Stumble into an EPA claim.
Yeah,
That's exactly
but this
right.
is one of those great areas of the law where the law kind of just matches best practice anyway, right? What's best to do practically. Because the reality is, if that is the new going rate for that position, your current employees can go to your competitor, right, and get that market rate instead of what they've been left with in your organization.
Right. Yep.
So that's a great point. Let's talk about now the individual negotiation situation.
Okay.
So the example you gave, which is there's a rate, right? Almost like it's non-negotiable, right? This is the rate for this position, now let's look backwards. But what about where someone says, hey, right, I'd love to work with you. Everything sounds great, but at my previous job or my current job, right, I'm earning X. So to make the leap over to your organization, I'm going to have to earn at least Y. And Y is more, right, than what your current employees are earning for that same position. What are your thoughts on that? Because I think that it happens quite a bit, particularly as we move up the food chain in terms of the types of positions we're recruiting and hiring for.
Boy, that's tricky. I'll be honest. And under your fact pattern, I'm assuming you mean that the Y that the new hire wants in order to come in would put them at a rate that's higher than current employees.
Correct. And let's just assume there's a gender difference too, just to bring it within the EPA
within
context
the
we're talking
confines
about here
of
today.
the EPA. Okay.
So
as it happens, I've had that fact pattern
me too.
in federal litigation.
Me too.
Right?
Yeah.
And the first comment I will make is that it is problematic and even unlawful in many states to rely on pay history to make decisions about what to pay a new hire when they come in.
So let's make sure that we're clear on
Okay.
that, because that's going to be surprising to a lot of
Right.
people. This means it's not only unlawful to ask on the application, which, by the way, a lot of applications still do, right? We talked in another episode about handbooks. Maybe folks should be looking at their job applications as well. A lot of applications, go through the work history and ask for wage.
For wages.
Or salary.
And to be clear,
So-
in Michigan, you can still do this, but in a
this is
lot
the
of other
trend.
states, there are restrictions on either asking and or relying on pay history.
So even if you take it off your application, in the individual negotiation, right?
Yeah.
If the prospective employee says, I want you to take into consideration my current salary when you're deciding what you're going to offer me here, even just considering that in that moment, right, could be unlawful.
It could be unlawful in many states, and even in Michigan where it's not unlawful, my experience, and I'll be interested to hear about yours, is that federal judges don't love that defense anyway, right? In other words, they don't find it compelling for an employer to say, well, the man was paid more at their last job, so we are going to pay them more than, for example, this woman who's already doing the same work, right?
Right.
A federal judge, based on my experience, federal judges like to say that's what's called pretext, which means they won't dismiss the case and you're going to have to try it in front of a jury.
So what is an employer to do then
Right.
when they have a candidate that is demanding a higher salary or would require a higher salary to come over and the employer wants to be able to do that? The answer is to raise others as well, right? That's the answer.
Unless, right, the answer is certainly to do a pay equity analysis within that group of people performing the same work.
Good point.
Right?
Not automatically.
Not
raised, but
automatically.
Compare experience.
Do that,
education,
yes,
et cetera.
and come up with objective criteria on which you're going to rely to determine what they all should be paid, and make sure then you're following that criteria.
Good
Okay?
point. Yep.
I would also add that whenever we're doing a pay equity analysis like that, and there could be concerns, right, about inequities, it's a really good idea to involve legal counsel, because then all of that could be privileged.
Good point. And while we're talking about pay inequities, when you discover them in an audit, is one of the tools in an employer's toolbox to lower the wages of some folks to get equity, Sarah?
No, interestingly not, Rebecca. And this is something that I think probably not a lot of people realize. The EPA actually makes it unlawful to lower any employee's pay in order to avoid a violation of the EPA.
Got it.
Isn't that interesting?
So everyone goes up. We don't go to the lowest common denominator. That's not the
If there's
solution.
discrimination concerns at play, that's true.
Right.
Let's take a step back for a minute, because we mentioned pay audits, et cetera. And you had sort of asked, well, what should employers be doing here, right? And we talked about paying attention to new hire rates versus rates of current employees, and doing that analysis and making sure that the equity is there. I will also add that I think many employers are in the rhythm of reviewing policies and handbooks on a regular basis, every few years, et cetera. I really, really believe that the EPA and equal pay is becoming an emerging issue in the employment world. And HR folks are going to be asked, if they're not already, to be doing these frequent pay equity audits to make sure that the business is in line with both the EPA, but also that their pay makes sense. Right? Again, it's an important employee retention issue. Nothing is more frustrating to a good, hardworking employee than to find out that for no reason they can understand, they're getting paid less than their coworker.
Right, and that goes hand in hand with market rate studies, right?
Yeah.
In a tight labor market.
Exactly.
This is, again, to repeat myself, but it's just best practice. It makes practical sense too, and I love it when the law coincides with what makes best practical business sense.
If not already, I really think these pay equity audits are going to be on the list of things that HR folks should be doing on a regular basis.
Yeah.
I mentioned this earlier. But if you're doing those, I would just highly, highly encourage them to be done under the attorney-client privilege.
Correct. Yes. Let's talk about something that I'm sure is on a lot of folks' minds that are listening to this. I'm just going to be their voice for a second. I'm imagining this is on their minds, because I know when I've had these conversations with clients, one of the first things that comes up is, well, how does that person even know?
Yeah.
Right? How does that person even know?
They shouldn't be talking about how much they
shouldn't
earn.
be talking about it.
Right.
And is it a violation of any of our policies that so-and-so told so-and-so, right? Maybe what they were making, or maybe it's what someone else is making.
Right.
Right? So what is your response to that? Because that almost always comes up in the first 5 minutes of these conversations, right?
Sure. And this one I know the answer to, right?
Well, thank goodness for that.
Yes,
Sarah.
exactly. And so what I'll say about that is the National Labor Relations Act says that hourly employees, at least, right, have a right to talk to each other about their wages. So employers can't prohibit that.
And that applies to organizations that have unions and also that do not.
Correct.
Right, because a lot of non-unionized
so policies
folks.
that forbid employees from talking about their wages to each other, those, quite frankly, are just unlawful under the NLRA.
So just assume.
Just
everyone
strike
listening,
that. If you've got one of those, just take it out.
Yeah, just assume everyone is going to know about each other's wage rates and conduct yourself accordingly.
Yeah. And I guess I think the thing I would add is at least right now, many businesses are advertising their starting rates, right? So it's no secret.
Yep.
It's no secret. Current employees, regardless, are going to know that people are potentially getting hired in and making more money than they are.
Mm-hmm. I have heard of one fairly large organization, not local, that has made public all the wage rates of all their employees within the organization, because they're proud of their pay equity analysis and the adjustments they made, and they believe it leads to a more trusting and harmonious workplace where everyone just knows.
Interesting.
And it's not a secret. So I'm not necessarily recommending that everyone listening do that, but it is an interesting concept that goes a little bit beyond this. But for our purposes, everyone listening should just assume that employees will know what each other are making. So don't blow off a potential landmine, assuming that no one will ever
that
even
nobody will
see
ever
that.
know. That's exactly right.
That is not good practice.
Yep.
Okay, so now let's talk about one of our favorite issues, training.
Yeah.
So this is another preventative measure, right, employers can take to avoid
And also
issues.
a theme in the EPA litigation in which I've been involved.
Also a theme in employment law in general and at Miller Johnson, to be
It's been
blunt,
valid
right?
point, yes.
We do a lot of training around here,
Right.
and we really enjoy it. But this is an area that doesn't get a lot of attention. So let's go back to the classic example that I raised, where it's an individual negotiation. Who is usually in the room, right? It's usually not the HR specialist or the talent, right,
It's
acquisition.
the hiring manager.
It's the hiring manager. And it's that person that the applicant is going to say, this is how much I'm making now,
Yes.
right? So this is how much I need to make here. And you may not even know that, the HR folks listening may not know that conversation ever even took place.
Which means then, so when you talk about training, you're talking about training that HR manager to understand that the implications of simply saying, okay, that's great,
Yes.
we'll go ahead and match that, that the implications of doing that are so much greater than that hiring manager might even know.
I think
That poor person is just trying to get the right person in the door. They have no idea. Right?
I think training leadership too, non-HR leadership, to be sensitive to these issues, right, could help prevent potential liability issues, but frankly also make HR's job a lot easier. So when HR raises a question and wants to dig a little deeper, right, and asks the whys, the people that they're talking to will understand why they're asking the questions. It will just save a lot of time and heartache, right, to have everyone on the same page.
That's exactly right. That's exactly right. And I'm even thinking to, again, lessons from litigation, right? I'm thinking to
Isn't that another podcast?
Yeah, some email communications, right, from hiring managers to each other about pay rates, and they just were not their fault, right? But they just weren't trained in understanding this law, and to know what to say or not say, and that can be problematic. I'll add too that I think organizations that do a better job with pay equity do something that I think is important, and that is they have an assigned individual, usually within the HR department, that approves pay increases, starting wages, etc.
Okay.
And part of that person's job is to know and evaluate who's also doing that work and viewing all of those decisions in that holistic way.
Brilliant. So
Right.
when a hiring manager, or they're not even a hiring manager, they're just a supervisor or manager,
Yes.
wants to give someone on their team a raise. Let's say we've been talking about hiring, but let's just talk about a raise for a minute,
Yep.
right? Because we know that's where some of pay equity comes from. We know that the studies show that men are more likely, right,
To get-
willing to
to
ask,
get increases.
to go in and ask when it's not an automatic type of thing, whereas women may not even consider going in and asking. So a male employee goes in and asks for a raise, and the manager would like to give him that raise and then ask HR to implement the pay adjustment, right? Because that happens too,
Yeah, sure.
right? You're absolutely right. It's really helpful for the person in the HR department to have on their checklist, if you will, right, what to do when approving this, to look at what everybody else is making in the same job code, et cetera.
Yeah.
And if there are disparities, does it make sense?
That's
Right?
exactly right. Yep.
If it's, and I know you made this point off camera, so I'll make it on. If the explanation is, look, the market rate has gone up, right? The market rate for so-and-so, our current employee, has gone up. He has brought that to our attention, right? So we think a raise is fair to keep him. Why wouldn't the same logic apply to the female?
Yeah. To other
employees.
employees.
Yeah.
Right. And hopefully, I can't emphasize enough for our listeners, and hopefully they're getting this understanding, is a lot of these inequities happen not with the intention of discrimination,
Right.
but because people aren't paying attention to the larger picture.
Absolutely agree.
Right? And so the focus really is, okay, how as an organization do we continue to look at this through a larger lens and not on an individual basis? Because when we look at pay only on an individual basis, that's when we unknowingly end up with disparities between men and women that can be difficult to explain.
When I've had these calls from clients, frankly, what I learn is the client is surprised when the claim
Yes.
comes in and thinks, well, I never even realized.
Yes, I didn't know.
I didn't even know.
I didn't know.
Yeah.
That's right.
But that is not a defense under the EPA, right? It can help minimize damages if it's not a willful violation, but it's not a flat-out defense. And once you're in it, you're in it, as I like to say about litigation, right?
Yes.
Realizing an oops is great for going back and fixing problems and doing better, know better, do better, but it doesn't just get you out of the litigation.
Right. So you can see why I've been losing sleep over this, because I feel like businesses who in their heart are trying to do the right thing,
Yeah.
are trying to hire more folks, right, are trying to increase starting wages, are trying to get people in the door to take the burden off current employees, right? These decisions are often being made with the right intentions, but I've seen them play out into unfortunate circumstances because people are not looking at the right things.
Right.
So I guess my takeaway, right, for our listeners is this is a fantastic time, right, to stop and think about what your organization is doing to stay on top of these pay equity concerns, and how are we going to address that and make sure that we don't have these that we don't unknowingly have these disparities that cause issues.
So what you're saying is you're trying to create a theme. We
Yes.
normally get the themes from the client.
I'm giving them the theme.
So
Yes.
this will be like a litmus test. We're trying to
Yes.
create a theme. We will see
Yes.
if then the actual calls and questions that come in the few months after this
Exactly.
airs, right,
Exactly.
have to do with pay equity.
Exactly.
And I know we both believe in pay equity, right, aside from legal compliance, obviously.
Sure.
Right? It's an important issue.
And I think it's an important
For us and for the
culture
folks
and retention
watching
issue too,
this
right?
podcast or listening.
Yes. Yeah.
Yeah.
Exactly right. So
It's
pay
the right
attention
thing to do.
pay attention to starting wages versus current employees. Think
Yes.
about a regular pay equity audit process,
Yep.
right?
And think about training leaders in HR.
Think
on
about
this issue.
training leaders in HR, and then our fourth point, I think, was really think hard about designating a person
Yeah.
to be trained in and understand this and approve pay increases, and then it's that person's job to take that holistic look at the people doing that same work.
Perfect. I
Yeah.
love it. All right. Well, hopefully we'll see some movement in this area, Sarah. And I
Thanks.
hope you feel better.
I do.
Now that you've gotten this
I
off
feel like
your
I
mind.
put it out into the world.
Yeah.
The world can do what it wants.
Well, the world will be a better place. That's just only it. All right.
Thanks, Rebecca. Have
Thank
a great
you,
day.
Sarah. See you later.